Good morning, everyone. My name is Brian Candelaria, and I'd like to. Right now it's 10:30, and I'd like to first of all thank everyone for being here. I know it's the last session before on the last day before the last lunch, so we're recording it, and hopefully, and the material at some point will be available. And if you have any questions, please be sure and let me know. So to start with, I'd like to point out that this presentation is my own. The opinions, interpretations of statute, case law are my own and should not be interpreted as establishing any attorney-client privilege relationship with Oklahoma Indian Legal Services, who I work for, and anyone watching this presentation. Finally, I'll be using terms like tribal nations, Indian country, and their common usage as legal terms through statutes, treaties, and case law. So I'd like real quick to do an introduction and overview as to what we'll be covering today. First part, we'll talk about kind of my biography and how it relates to how I got here today, and on the important issue of climate control, or climate effects of climate change and disaster in Indian country. So we'll be talking about how as far as the understanding and the importance of federal Indian law, my role as a staff attorney and as the Center for Disaster Philanthropy Disaster Navigator. I'll explain more about that. I'll talk about who I work for as far as Oklahoma Indian Legal Services, and what we do, the importance of disaster law, how our expertise in understanding jurisdictional issues, and in particular land issues, which is part of what we're here today, and then I'll talk about some ideas and some thoughts what I think and propose would help as far as addressing climate disasters, not just climate disasters, but disasters of any sort, including climate disasters in Indian land, in Indian country, and then, like I said, some possible solutions. At least one possible solution that I kind of want to put forth and present. Again, my name is Brian Candelaria. I'm a staff attorney, disaster navigator. There's my phone number and extension. My email is up there. I like to put that at the beginning. That way folks have time, like I said, as we get towards the end, might be rushing and going through everything and forget to make sure that you have contact information in case you have any questions for me after today. We're in Oklahoma City. I was born in Albuquerque, New Mexico. Went to high school both in New Mexico and in Norman, Oklahoma. I received a master's degree in Indigenous Peoples Law at OU. I've been practicing the law since 2020. I kind of focus on end-of-life documents for disaster preparedness purposes. We assist Oklahoma tribal citizens and communities as disaster navigator with disaster recovery and response. Been married for over 22 years, and we've shared, my wife and I have shared a home with over 10 cats, but never more than 4 at a time. So I want to provide a little brief, as we come in today, all of us have our different stories as to why we're here and how we got here. Mine, I think, is helpful to understand why I'm passionate about disaster law, and in particular about helping our tribal citizens in tribal communities, not just in Oklahoma, but throughout the United States. As I said before, I was born in Albuquerque, New Mexico. My father was a construction worker. He worked in school projects in Zuni, New Mexico, Cuba, New Mexico, and in the mid-'80s he helped build the BIA building on the Mescalero Apache reservation. We lived in Ruidoso at the time, and on my mom's side of the family, she's from what used to be, when I was growing up, a small town called Los Lunas, which is about half an hour south of Albuquerque. Now it's part of Albuquerque, as far as it's not too much far. It's a breakfast community, as far as its size now. But in particular, my mom's family was near, and at various times, my mom's family lived on the Esleda Pueblo. They're not enrolled. I'm not an enrolled tribal citizen, but again, taking from that, my mom lived in that area, and of course grew up. We moved to Oklahoma, and then I like to point out that in Oklahoma, in high school in Oklahoma, we had the extent of any Indian law, or any Indian history, was 2 weeks. One semester, 2 weeks during the junior year of high school. And so I point that out because, like most people who are not enrolled tribal citizens, I never truly appreciated the rich tribal cultural heritage that surrounded me, whether it was in New Mexico or in Oklahoma. And it wasn't until I got older that I really truly appreciated what was all around me. And for me, is when I got my master's degree in legal studies in indigenous peoples law through University of Oklahoma Law School, that I knew I wanted to have a degree and specialize, a law degree, and specialize in Indian law, which I have. During the master's program at OU and the law school program at Oklahoma City University Law School, which is where I got my law degree, I learned the legal manipulation used by the federal government in the past, and you can also argue, it continues to this day, to excuse the various attempts to assimilate, eradicate tribal nations and their peoples. I came to understand that federal Indian law is about a pendulum of eras. And in fact, even before the Cherokee cases in 1831, which we'll discuss more later, I think what really started for me was a letter from Thomas Jefferson to Indiana Governor William Henry Harrison. It was dated February 27th, 1803. And what particularly chilled me was what he said in that letter, just black and white. There, you can go to foundersarchives.gov and look up the documents for Thomas Jefferson, and right there in his letter, he says, and I quote, when they withdraw, meaning the tribal nations that were in the United States at the time, when they withdraw themselves to the culture of a small piece of land, they will perceive how useless to them are their extensive forests, and will be willing to part them off from time to time in exchange for necessaries for their farms and families. To promote this disposition to exchange lands which they have to spare and what we want for necessaries, or we shall push our trading houses and be glad to see the good and influential individuals among them run in debt, because we observe that when these debts get beyond what the individuals can pay, they become willing to lop them off by cession of lands. At our trading houses, too, we mean to sell so low as merely to repay us costs and charges, so as neither to lessen or enlarge our capital. This is what private traders cannot do, for they must gain. They will consequently retire from the competition. We shall thus get clear of the past without giving offense and umbrage to the Indians. In this way, our settlements will gradually circumscribe and approach the Indians, and they will in either time incorporate with us as citizens of the U.S. or remove beyond the Mississippi. The former is certainly the termination of their history, most happy for themselves, but in the whole course of this, it is essential to cultivate their love. As to their fear, we presume that our strength and their weakness is now so visible that they must see that we've only to shut our hands to crush them, and that all of our liberties to them proceed from motives of pure humanity only. Should any tribe be foolhardy enough to take up the hatchet at any time, the seizing the whole country of this tribe and driving them across the Mississippi as the only condition of peace will be an example to others and furtherance of our final consolidation. I read that, and it was as if it was as if the blinds have kind of came off my eyes, and I realized the important work that needed to be done as far as for me. So I then knew I had to find a way to help and contribute to preserve Native sovereignty. During my 3 years as a law student, I worked as an intern, especially during the summers, and have been working for the past 3 years as a staff attorney and for the past 2 years as disaster navigator for Oklahoma Indian Legal Services. Oklahoma Indian Legal Services, we have an office in Oklahoma City. We have a clinic in Ada in partnership with East Central University. We have staff attorneys in Tahlequah. During the pandemic, we worked basically from home, and I'll show you kind of some of the events that we did, that we held, that were very, very rewarding as far as still doing the mission and still doing what needed to be done especially for tribal elders. So we have an attorney in Ada, in Guthrie. There are a couple of us over in Norman. But we have 8 attorneys. We have 8 support staff. We have some various interns. And we serve all 77 counties of Oklahoma and all 39 federally recognized tribes of Oklahoma. We serve income-eligible enrolled tribal citizens. We do this mainly through grants through Legal Services Corporation, which is congressional. It has a congressional line item directly from Congress as far as the budget. And so we are incorporated with them. We have a sister organization through Legal Services Corporation, and that's called the Legal Aid Services of Oklahoma, or LASSO. They're our sister organization, and we do quite a bit of collaborating and cooperation with them. We also work through the Center for Disaster Philanthropy. As far as grants, we get grants from various tribes for various matters. A couple of the tribes we work with, in particular, with dealing with Indian Child Welfare Act, or ICWA. We also help as far as provide sometimes criminal defense. Usually, if a legal services organization is funded by Legal Services Corporation, usually they can't practice criminal law. But because of our expertise, especially in particular with tribal law, we can help and do often help with criminal cases, dealing with tribal courts, and through some of the tribes, we act as basically public defenders for their tribal citizens, so that through the tribal courts, their citizens are represented and are assisted. And then, of course, we get funding through the Indian Land Tenure Foundation. For example, with the Indian Land Tenure Foundation, for Legal Services Corporation, as far as income eligibility, our applicants, folks who are applying for our services, their income threshold has to be less than 200% of poverty. And you realize just, after a while, you realize just how low that is as far as income. And so there are a lot of times that people are over that, and we can't help unless we can fit them through other grants. One of the grants is the Indian Land Tenure Foundation, where we're able to help if they have trust land and they have a priority or need that we can help with, like probates or doing a will and other things. Through the Indian Land Tenure, that has afforded us the opportunity to serve 113 enrolled tribal citizens who would not have otherwise been able to be served through the Legal Services Corporation. 100 of them were wills. About eight of them were advance directives and powers of attorneys, and then 5 of them were transfer on death deeds. A good portion of that was through the depths of the pandemic, and I'll show you some of the ways that we were able to serve our tribal citizens. Our priorities, as per our board of directors, we've got a board of directors and our grant funders, is the Indian child welfare cases. We do a lot of those. We're keeping an eye out. Just as an aside, on a Supreme Court case called Brackeen that was heard in November. The opinion should be coming out in June, towards the end of June. But we are, we help and speak up for folks regarding the Indian child welfare. We also, one of the second main priority grouping is protection of sovereignty, and that is, helping with tribal codes. In certain situations, and just doing whatever we can to help the tribal nations, as to collaborate with them to make sure that that sovereignty is protected. Estate planning and natural resources, that's a good chunk of what we do. Then also individual rights entitlements. This coming up here in the next couple of months will be graduation time, and so a lot of seniors who want to make sure that they are able to express their heritage, whether that's through wearing a eagle feather or some sort of cherished item. We help in making sure that that can be done. If someone asks us, as far as with individual school districts, and then legal information and advice. During the depths of the pandemic, we provided a lot of that legal information and advice. And during a couple of years ago, and I'll talk more about it here in a bit, was the McGirt decision, the Supreme Court decision. And so we did a lot of getting information out as to how that affected tribal citizens. These three here, estate planning, natural resources, individual rights and entitlements, legal information and advice, these and the importance of land titles, these are huge as far as disaster preparedness. One way we help is bringing up the titles for folks. We try and stress, we go out into the communities and stress the importance of having the titles brought up. You have a lot of generational housing, and so where a person who has lived on the land gets ill, usually it's a parent or a grandparent, and a child or a niece, nephew come in, help them during their so that they can stay in the home, still have a little bit of independence, but be with family. Person ends up dying. It was in their name. The probate needs to be done in order to make sure that the title is in their name, so that they can have the rights associated with land ownership, and that includes, if a disaster comes, taking care of being able to get grants through FEMA or the Small Business Administration through the Stafford Act. We go out and help as far as stress the importance of APRA, American Indian Probate Reform Act. We stress the we go out and stress the importance and the difference of the APRA intestacy system, and then how our wills can help through that, and the Oklahoma Oklahoma State, the state of Oklahoma probate and will succession, property succession and conveyance through wills as well. We also talk about and get out to folks the importance of understanding restricted land. In Oklahoma, we have trust land with a capital T, and we also have restricted land through U.S. The Title 25 U.S. USC Section 375 about the 5 tribes: Cherokee, Chickasaw, Choctaw, Muskogee or Creek, and Seminole. And so their property, their conveyances of their land are handled differently. And so we get out into the communities and try and educate folks about it. So again, talking about the importance of the land titles, connection with the 3 categories that I discussed above, the probate we connect through the probate and the courts, and we try and distribute as much information as possible to the communities that we serve about the Indian Land Tenure Foundation and about the great work that they do and the resources that they have. So we serve the clients in court, we serve in state court, sometimes in federal court or through CFR courts, and we often serve in tribal courts. We serve, again, we serve the tribal communities by distributing information through our partnerships, whether they're tribal, state agencies. We have a lot of folks that we collaborate, especially in the disaster and disaster and climate response issues through state agencies. Oklahoma Emergency Management and Homeland Security is an example. There are a couple of schools. The ECU has a water institute, a water rights institute that we work with. We have partnerships through FEMA as far as the federal, and of course with the BIA and the various realty offices and the office, so So we have that, and we have nonprofits and community engagement partners. Our community engagement partners include the Institute for Native Arts and Media. We coordinate with them almost once every month to do Ask a Lawyer events. And then we also coordinate with tribal newspapers, Oklahoma VOAD. It's Voluntary Organizations Active in Disaster. We're able, as a partner organization, OILS is a partner organization, and so we connect with folks like the Red Cross, Salvation Army, Habitat for Humanity, and various organizations like that to help and make sure that when a disaster strikes a tribal community, that there are resources available, and that it doesn't tax. What we hope to do is have where it doesn't tax the tribal resources, as much as possible. So, and then one of our other partners is the Intertribal Emergency Management Coalition, or Item C. So, importance of clinics and social media for engagement purposes. Even during the depths of the pandemic, we held clinics, and we did drive-through clinics. And so this is a real quick example. I just want to show kind of what we would do. So they would drive up. We would do a lot of the footwork, a lot of the advanced work. They would do an application over the phone. We would contact them. They would send us information. We would complete questionnaires. We use that information to draft wills. And then this is a good example of what we would do to execute the will. We'd have two witnesses. Under Oklahoma law, you need two witnesses and a notary. So we would have this. This one was in the park. We just have them pull up. As you can see, we were fully masked. Again, this was a couple of years ago during the depths of the pandemic, but everyone was fully masked because, as you know, I don't have to point out that the tribal communities, in particular, the elders, were particularly at risk, and I dare say there's not a family in here, there's not a person in here that wasn't affected as far as that goes. So we did everything we could to make sure that we had even these events as safe as possible. We would still have to go to court. Oklahoma, they did not, it was hit and miss as far as whether or not they closed particular courts. So we still went to hearings. We still did what we could. Again, this is a good example right here of doing this. Again, we would have people park in as far apart as possible so that attorney-client privilege was respected as much as possible during the process. And this is an example. I don't think you can see it, but in the back we had a power supply, and we were able to even do it right there out in the parking lot. So one of the main reasons in the importance of disaster law and climate disaster law in particular for Native communities is that as far as what's called the disaster response phases of disaster. An incident occurs, response, maybe it's rescue or an emergency, and then you have early recovery, and then long-term recovery. Then you mitigate through, like FEMA, they need you to have some sort of mitigation plans and for funding, and then you prepare and get ready for the next events. So while some tribal citizens may live in urban communities, tribal communities are often in rural locations. With rural communities come rural community issues like lack of resources, lack of materials, great distance to overcome for medical and health services, and even legal services. In Oklahoma, there are a couple of counties that in the whole county, there are less than 5 attorneys. And one of the attorneys will be a judge. So you have what are basically legal deserts. And so in Oklahoma, there are high poverty rates, especially in rural and small towns. In 2017, there were over 621,000 Oklahomans that were below the poverty level, and that's basically 15.8% of the population, or basically 1 out of 6 Oklahomans. Oklahoma's poverty rate since 2008 has been higher than the national average. The poverty rate was 2.4 points above the national average, and had been an increase from 2013. Again, poverty, a lot of these issues, climate change, disaster and stuff, the folks it often hits are who are disproportionately affected are elders and senior citizens and the children. So poverty rates were higher among children, and more than 1 in 5 Oklahoma children live in a household with income below the poverty line, and then 1 out of 10 seniors live below the poverty line. 1 in 3 Oklahomans are single mother households, and so again, disproportionately affects rural communities. So this requires a need for collaboration and partnerships. In addition to nonprofit, private, volunteer, and faith-based organizations, the major players are often either state, federal, or tribes. And as you all know, with that often comes jurisdictional issues. And so at Oils, one of the things we do is try and understand the jurisdictional issues, in particular the law, past, present, and potentially the future. Again, I was talking about Burkine. We helped folks as far as McGirt and various other cases that have come up. So real quick, as the pre-McGirt, you had the early Supreme Court decisions that were known as the Cherokee cases, Johnson versus McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. Johnson versus McIntosh established the discovery doctrine. Cherokee Nation versus Georgia established the guardian-ward relationship. And Worcester versus Georgia established the precedent that only the federal government and not state government would control terms of trade and intercourse with Indian nations. The foundational concepts established by the Cherokee Nation cases allowed the U.S. Supreme Court to acknowledge the basic but limited sovereignty of Indian nations. As far as civil cases, one of the most important civil cases that there is Montana versus United States. That established what is known as the Montana Rule, where though Oliphant only determined inherent tribal authority in criminal matters, the principles in which it relied support the general proposition that the inherent sovereign powers of an Indian tribe do not extend to the activities of non-members of the tribe. There are 2 exceptions. A tribe may regulate through taxation, licensing, or other means the activities of non-members who enter consensual relationships with the tribe or its members through commercial dealing, contracts, leases, or other arrangements. And then the second is tribe may also retain and exercise civil authority over the conduct of non-Indians on fee lands within its reservation when that conduct threatens or has some direct effect on the political integrity, the economic security, or the health and welfare of the tribe. And in particular, that part will come in when I talk more about, in the end, one of the ways that, one of the possible solutions is developing a model code that tribes can use in regards to disaster preparation, disaster response, and emergency management issues and response. And so being able to exercise the Montana exception, the second Montana exception, will be key, I believe, in establishing model codes that can be used and enforced in Indian country. Post-Montana, there are various cases that demonstrate the Supreme Court's use of the split status approach. And by split status, I mean you have to look at the status of the people involved. Are they enrolled tribal members or not enrolled tribal members? And where does the enforcement, where does the jurisdiction stand? Is it on in Indian country or not? Is it, so in particular with criminal cases, did the event happen on tribal land or a like area, or did it not? And so that split. So when we're talking about, especially with that land, and McGirt for Oklahoma was very important because it established that basically the east side of the state, where the 5 tribes were had not been disestablished, and so therefore those have various ramifications, not just in the criminal realm, but also in the civil realm, and on issues like taxation and disaster response. So again, the 2 important factors for criminal jurisdiction and civil jurisdiction, especially with Montana, is Indian status of the land involved and Indian status of the parties involved. So federal understanding as far as is that you have statutory definitions of Indian country, in particular Title 18 U.S.C.A. Section 1151 as defines Indian country, except as otherwise provided in sections 1154 and 1156. Term Indian country, as used in this chapter, means all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent or including rights of ways running through the reservation. And I'll stop right there. For those, there was a great presentation yesterday regarding rights of ways, and so that falls within that. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And then C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of ways running through the same. So again, federal understanding is then you have various definitions of that are used in the Indian Child Welfare Act, which is 25 USC Section 903, and then also the disaster relief in the Stafford Act, which is 42 USCA Section 5122. Indian tribal governments means that the governing body of any Indian or Alaska Native tribe, band, nation, pueblo, village, or community that the Secretary of the Interior acknowledges to exist as an Indian tribe under the federally recognized Indian Tribe List Act of 1994. And then case law, of course, referring again to McGirt, and then Castro Horta is another case as far as the power involving enforcement to non-tribal citizens. In Oklahoma, the state understanding is under Title 74, Oklahoma Section 1221, under state tribal relations. And so the state recognizes the recognition of Indian tribes through the Department of Interior and Bureau of Indian Affairs. The state of Oklahoma recognizes the unique status of Indian tribes within the federal government and shall work in a spirit of cooperation with all federally recognized tribes in furtherance of federal policy for the benefit of both the state of Oklahoma and tribal governments. And I'll stop right there. For anyone who is in Oklahoma, who works in Oklahoma, can attest to, right now the state has done everything it can to not work and cooperate with tribal nations. And it started from day one, and as far as the current governor, but not to get political, but it just demonstrates how precarious tribal relations and states can be. One administration is all it takes to all of a sudden have someone fighting you and even basically ignoring and trying to ignore your existence and sovereignty. And so and that can happen in Oklahoma. It can happen anywhere in the United States. And these are the realities. These are the realities on the ground. So the governor, supposedly, as far as in the statute, the governor is authorized to negotiate and enter into cooperative agreements on behalf of the state with federally recognized tribal governments within the state to address issues of mutual interest. The government may elect to name a designee who shall have authority to negotiate and enter cooperative agreements on behalf of the state with federally recognized tribes as provided in this section. And so, again, we don't necessarily have that sort of cooperation in the state of Oklahoma. So, and that may be even more of issues for folks who are in who are in public law 280 states. Oklahoma is not one of them, but again, state understanding of statutory law and actual practice are very important, and that's part of what we have to work with and address in Oklahoma. That these in the end, it affects conflicts between states and tribal nations. Whether whoever's in charge, as far as the state understands or not, it is supposed to be sovereign, and it turns out to be sovereign versus sovereign often. So tribal understandings of the situations are often through tribal codes, ordinances, role of tribal courts, in particular how lands held in trust by the federal government are handled. And again, in Oklahoma, we're unique regarding the 5 tribes. So I say all of this in that disaster land connections, especially in the age of climate change, what can we do, those of us who want to help communities and tribal nations survive through disaster, whether it's created by climate or man-made or through disease or what. My argument is that we need to get to the higher ground. We need to get to higher ground before those who want to deny and deny tribal sovereignty, before they get to there. And basically what's at stake, I believe, is everything. And in particular, recovery from disasters and protecting tribal citizens. Michael Lynn Steele, who is a member of the Seneca Nation of Indians in New York, wrote a 2020 Arizona Law Review article entitled Indigenous Resilience. And in it, she did a fantastic job of pointing out, again, what is at stake. She noted that tribes must prepare for the consequences of climate change, which poses a particularly dangerous threat to many tribal communities and their ability to maintain their core identity and function. Professor Rebecca Sosi has described the threat to tribes from climate change as potentially genocidal because the unique cultures and identities of many indigenous peoples are location and resource specific. Tribal access to adequate water, already a challenge for some, may face additional restrictions or scarcity in the event of drought. On the other hand, many find their homelands submerged by rising sea levels or subject to intensifying storms or uncontrolled fires. Warming Arctic oceans threaten the subsistence resources of Alaska natives on both land and sea. Despite a limited role for tribes in national and international planning to combat climate change, and despite a relatively small carbon footprint, climate change may take an acute toll on tribes who already face ecological and economic vulnerability. While the Bureau of Indian Affairs has established a tribal climate resilience program to assist tribes to prepare for climate change, the Trump administration has proposed eliminating the program's funding and remove references to climate change from the program's website and materials, unquote. And so in fact, yesterday, while I was preparing, finalizing my presentation, I noted that there was an article on CNN that talked about Wall Street, and it may still be up, is that Wall Street firms are starting to invest on buying land for the water rights, for the purpose of making money on the scarcity of water. And so again, these are issues that need to be talked about, and it's my hope that today we can get some discussion going as possible for possible solutions. So federal Indian law and federal statutory law appears to suggest that to protect sovereignty, tribes must exercise sovereignty. And so I argue that one way to do this is to create model codes that address disaster recovery and responses and emergency management practices. In particular, not not Montana, but the case of City versus Sherrill, City of Sherrill versus Oneida was a Supreme Court case in 2005 that exemplifies that you have to exercise your sovereignty. You have to do what's needed in order to demonstrate in particular to the federal government, that you are taking steps as a tribe to assert the sovereignty that you are due. Model codes should be used to help the tribal nations and tribal communities prepare for disaster. In particular, use them to address water rights and drought, increasing flood events, increasing number of fires, health, disease, and pandemic events. We all know about that one. And interstate transportation events. You have only to look at over the past month, the two railroad events, crashes, and what would happen jurisdictionally if those happened through a right of way that was in Indian land. Model codes should be used to help tribal nations and tribal communities prepare for disaster related by using citizen input to establish executive, legislative, judicial powers when a disaster occurs in order to help the community prepare, respond, or mitigate a disaster. One of the great things about tribal governance is the fact that it's ideally connected to the citizens of the tribe, and that having a voice as to how we're going to respond to a particular event is key, and that's what model codes can help with. How are we going to address, for example, taking the COVID pandemic, how are we going to address when we don't want, when a particular tribe does not want others going onto tribal land or passing through, as far as vaccination status or taking social distancing statuses into account. How are tribes going to do that? How are they going to address those issues? That can all be decided in advance, and with citizen input. What do the citizens say? What do the citizens want? Model codes should be used to help the tribal nations by giving tribes firm yet flexible authority to collaborate, cooperate, coordinate, and communicate with federal, state, and other tribes, and nonprofit assistance organizations and agencies before, during, and after a disaster occurs. Model codes can be help tribal nations and tribal communities, helping them address and prioritize culturally unique characteristics and customs to ensure that what makes the tribe a tribe is more likely to survive the depths and disruptions that disaster creates. Creating communities that are prepared for emergencies creates resilient communities and individuals. Mindful of that, again, I refer to Ms. Steele's eloquent words in her law review article. She says that my grandmother, Norma Seneca, was keenly aware of the improbability of the survival of the Seneca people in western New York after centuries of efforts to remove and terminate them. We were not supposed to be here, she would say with a sly and defiant gleam in her eye. But we are here. That's what we do. We survive. That same resolute determination has characterized the survival of many Indian tribes. For all the efforts to seize their resources, break their bonds, quiet their language, still their dance, and strip their sovereignty, the tribes survive. Tribes have shown themselves to be resilient institutions, legally and culturally. They have mitigated, adapted, and transformed to maintain their core purposes and functions in the face of repeated existential threats. Tribes are enduring legal entities in part because they've been resilient in their response to legal assaults. While no one would reasonably suggest that tribes are better off for the assaults on their sovereignty and the threats to their very survival, many tribes are thriving in spite of the assaults and have grown their capacity to respond to challenges to their sovereignty. Rather than allowing themselves to be consigned to history, in American history, policy, and culture might have wanted it to have, many tribes are highly effective in carrying out their core missions to preserve and transmit their culture, exercise inherent sovereignty as self-determining communities, and facilitate opportunities for their membership to thrive. There are important lessons in the resilience of tribes about adapting to changed circumstances and rebounding from threats without losing the integrity of identity. History warns that future threats and volatility are always on the horizon. By embracing the indigenous principles that have helped the tribes to survive and thrive, tribes can prepare and meet and even grow in strength from future threats. So too, as resilience theorists contemplate the potential of existential threats from climate change, political volatility, and social vulnerability, they may well be advised to look to the tribes to better understand how to prepare for and respond to these threats. And so, in conclusion, model codes addressing disaster and emergency management can be used to help tribal nations forge their own paths before a disaster occurs. So when a disaster does occur, tribes can be on the higher ground together. They can do so while retaining and remaining the distinct, unique tribal nations that they are. Thank you very much for your time. I really appreciate if anyone has any questions or would like to exchange any information, I'd be happy to. But thank you very much for your patience and time. And if you'd like the site for that resiliency article by Ms. Steele, I can give you the site and anything else. But thank you very much.
Thank you. I'd like to say, just share a little experience I've had. This was very helpful in 2015 on the Navajo Reservation. The San Juan River was impacted by the EPA Gold King mine spill, where a breach occurred from one of the ponds. So that morning, I was watching the news, and as a former archaeologist, I'm very familiar with the land status, the sacred properties, sites. I worked all across the reservation. So when that happened, the very thing I did was, and I was also a chapter official, so in my capacity, I knew that I had to jump into action. So 5 a.m, we heard about the spill into the San Juan River. Well, actually, it's the Animas River, which connects to the San Juan River, that empties into the Lake Powell Page area. I heard that. I called my sister, who was also an official. She's a grazing official. She monitors animal activity. So we sprung into action. We got to the chapter by 7 a.m., started making calls to the counties, to our tribal offices in Window Rock, which is 2 hours away. We were bombarded with all agency jurisdictions. It was the Army Corps of Engineers, it was the BOR, EPA. The tribe did not have anything in place. We, my sister was able to call the division of her program, grazing program, and they were able to bring mounted horses, motorcycles, ATVs. So they rounded up cattle and horses that were along the rivers on both sides. By then, from Colorado down into New Mexico into Utah. By then, the county was informing us that, oh no, the spill hasn't gone down there, so you don't need to worry. But we know how quickly water travels, the muddy waters from the mountains down into our flatlands. We weren't taking any chances. So we did our part by, within that day, we had all the animals quarantined. My sister was able to call other local agencies who had those portable pens and had animals locked up. We identified corrals where we could pin some of these animals. We didn't get tribal response until 3 days into all of this, and I took time off from work. I says, I have more important things to do here. It was a mess. It was just chaotic. We finally, actually, in the second day, late that afternoon, we were contacted by the state's EPA. They were on site by that night. They set up a temporary tent command. And by the second day, we were full swing, getting truckloads of water from different agencies, BOR. They had fuel, water trucks that were able to haul water for these livestock. Our Navajo agricultural products industry contacted us that night and told my sister they're going to haul feed for the livestock. But this whole time, our tribe was just struggling. Nobody from the headquarters. So it was between my sister and I and the locals. We were able to maintain this whole disaster. And I just heard my husband text me Tuesday that the EPA is finally doing their payouts. And it took from then, 2015, to now. And I'm just sitting here thinking, imagine, now when I go home, I'm going to make sure that our community has a national plan like this, not just depending on our tribal nation, the administration of the tribe to handle this. I'm realizing that there's so much at stake where we live. We're fortunate we have a year-round water supply, our source is there, but knowing this now, I'm seeing where we could be that much more ahead of these disasters. I know there's 2 other problem areas, sewage treatment plants. They're right there on the floodplains, and if there's another breach to happen, most likely it's the city's sewage plants. These are huge. They're not small compared to what we've seen in our communities. But this is thankful. I'm very thankful. This is so enlightening to me. I know what you're talking about are those jurisdictional issues from the federal all the way down to the tribal sector. Thank you.
Yeah, I appreciate that. I remember that incident, of course, contaminated with heavy metals, and the river, if I remember correctly, turned orange, and I mean, it was horrible. part of also that is a good point is that tribes preparing now can establish and point out some of the important statutory and case law foundations for their particular model codes. And sometimes that can be treaties. What's ironic to me is that a lot of the treaties, you know, from when Jefferson was trying to have force agriculture upon the Indian nations, that they would often, one of the carrots would be water rights. And now we've got tribes that have very valuable water rights, and that's through treaty. So if a tribe has that, they need to, you know, in some way incorporate that within their model code, so that, again, it further establishes that right, so that when the cities of Los Angeles, Las Vegas, Phoenix, when they go through, you know, it's easy to think, well, you know, the reservoirs are now full on March 23rd, 2023. The reservoirs are back to being full, and life can go on, and we got through that. That can change. That can change months from now. That can change just weeks. So it's best to be prepared, and whether that's whether that's establishing and making sure that you know the treaties that establish the water rights, if you're looking to incorporate that, and then what will happen if a company like a railroad or a mining company that, you know, after a disaster occurs, you can guarantee that they're not going to survive bankruptcy, and then everyone is out, and except for the people whose land and whose resources were affected. So again, I think that model codes can be extremely helpful, and can help at least have the conversation of disaster preparedness, disasters related to climate change, and disasters in general, man-made included. And so I think they can be very valuable tools.